Hey, it's Ben. Rahul and I started this podcast because we love hanging out with fellow trial lawyers and sharing ideas that can make us all better. And both of our firms also regularly collaborate with other lawyers across the countries in cases where we can add value. If you're interested in collaboration, or even if you just have a case or an idea that you want to bounce off us or brainstorm, Rahul and I are going to be hosting confidential case workshops the first Wednesday of each month. So here's how it works. If you have a case or an idea that you want to talk about or brainstorm with us, just send me an email to ben@elevate.net, ELAWVATE.net, or go online to elevate.net and submit a case workshop request. We will schedule you for a confidential 30-minute Zoom meeting where we can talk about your case to see if we can help. If you feel like there would be good value in collaborating on the case further, we can talk about that. If not, that's okay too. We enjoy helping other trial lawyers because we know someday you'd be willing to do the same for us if we needed your help. So again, if you're interested in workshopping your case with us, just send an email to ben@elevate.net or fill out a case workshop request at elevate.net. And Rahul and I will look forward to chatting with you soon. This episode of the Elevate podcast is brought to you by FileVine. FileVine has a software program called Lead Docket, which is the gold standard for managing your new case intakes and leads, your Glenn Gary leads, your Glenn Ross leads, and all of your other leads. So check them out at FileVine and manage your leads. We're also brought to you by Steno. Rahul, you guys work with Steno?
Steno is the best in court reporting services, not just in court reporting services, but even some of their technology tools. We're talking about AI a little bit on this podcast, and their transcript genius, where they can summarize and take interrogatories based on deposition transcripts, is so useful. If you haven't tried it, definitely try it.
We're brought to you by Hype Legal. Hype Legal does digital marketing, web development for trial firms. It's owned by our good friends Micah and Tyler. They recently redeveloped our firm's website, so you can check our website out. If you like it, give them a call, and they can help you out too. And finally, we're brought to you by Expert Institute. Rahul, you guys work with them, right?
We both use Expert Institute because you always need to be cutting edge in the experts that we use in our cases. Going to the repeat experts every single time is going to make you a lesser lawyer, and you always want to keep up, and the best way to do that is with Expert Institute. Welcome to the Elevate podcast. I'm Rahul Ravipudi.
I'm Ben Gideon.
Ben, we've got, this dates the podcast, but we've got our big game, Patriots versus Bills, coming up. I don't even understand why your team is leading the AFC East right now. It's really pissing me off. I'm hoping that changes before the end of the season.
Yeah, I know. Well, Buffalo's favored. We just looked that up by 1 point, right? But I would bet on Buffalo because of New England, won the last time, and they're looking for revenge coming to Foxborough. But come playoff time, I like our chances better. I think the team just looks better overall than Buffalo. I think your window has closed, sadly.
I mean, there's so many layers of rage baiting that just came through that comment.
I was just trying to trigger you.
You just succeeded. You succeeded. Oh my gosh. Well, talking football and talking good football teams, another shocker, the Chicago Bears. I can't believe it. And that's a perfect segue into another unbelievable person, Pat Salvi. Thanks for joining us on the
quarterback
podcast.
Of the Chicago Bears, right?
That was my dream growing up. It didn't happen, and now I'm cheering on Caleb Williams, and we'll see how they do. Currently,
he was picked ahead of Drake May in the draft, right?
I know. Hey, that's we got to look at the long story. The short story right now, you guys got the best of it, but we'll see. I love what the Bears are doing. Tough loss to the Packers. We get them again in 2 weeks, but I remain in a state of depression because my Fighting Irish were left out of the college football.
Oh, yes, they were.
Woo, that was rough. Yeah.
I've never seen a team take it more unhappily than the Fighting Irish.
We don't go silently, We're doing what we can to make sure it doesn't happen again, I think. So we'll see.
Well, Pat, I've had the privilege and honor of getting to join the inner circle at the same time as you. And then I had the intimidation factor of then looking up and seeing who's going to be in my pledge class, and then seeing all the $100 trillion verdicts that you've gotten back to back to back to back. But the silver lining is you're younger than me too. So I mean, it's like,
And
oh
better
my
looking, but I
God,
didn't need to
better
mention that.
looking. Yes, yes. It's absolutely amazing what you've done in your career. And we want to talk all about that and how you got to where you are and how you focus on longevity and how you're going to continue to do this for many, many years to come. Tell our listeners a little bit about how you became a trial lawyer.
It starts with really a lot of good fortune. I'm not going to pretend for one second that I haven't stood on the shoulders of some great trial lawyers, and it really starts with my dad. So, I can remember being in high school or college talking about cases, working at the office. I remember one time my dad and we went on a run, and it was maybe a week or two before he was starting a trial. I was in college. I was just kind of working at the office doing whatever tasks that were probably unnecessary, but licking stamps that didn't need licking, and but went downstate Illinois with my dad, and we were going on a run, and he was telling me all about the case, and it was just fascinating. And it really was something that interested me, although I wasn't entirely sure, but it was certainly of great interest. And so then as I transitioned into law school and into my legal career and started to try cases, I would say for a first number of years, I didn't try as many cases looking back on it as I should have. And it's definitely a cautionary tale. I try to tell to the lawyers at our office to just try as many cases as you can. You don't have to take the pill and settle a case that should settle for 50,000 for 30,000. Go try the case and try to beat that offer because you can, and you're going to get great experience. And in all likelihood, you're going to help your client out along the way. And so after a number of years of probably an approach that could have been a little different and could have accelerated my trial experience a little bit faster, we really, after I'd say about 7 years of practice, just as a firm and as a philosophy, we kind of did away with, let's settle our good cases and, try the ones we have to. And instead, we took the position that, we're going to turn down what's, a lot of times going to be good money and try our best cases. And I think with that philosophy, number one, there's good reason to do it. And number two, as we all know, it's a lot more fun, a better experience to try good cases. You're of course going to have a greater likelihood of success. And so between that philosophy and also learning from my dad, Pat Salvi Sr., along with the other named partners at our firm, one of which is Mike Schostok, who passed away from a glioblastoma at an early age, but I had the good fortune of practicing with him, and David Pritchard as well, who retired a few years ago. And so learning from those three, primarily my dad, but those three for sure, was really amazing. I mean, I came into a firm, I have a different story than a lot of people, although I think you do see a lot of children of trial lawyers kind of be drawn to it. But my story is certainly a great opportunity. And my belief is throughout my legal career, the last thing I would want to do is squander great opportunity. And so I've tried to maximize it and then bring that to the rest of our firm because now we've grown to a 22 lawyer firm, and we've got a lot of young people. And one of the exciting things is trying to pass that along and have great trial partners, as you mentioned, longevity, Rahul, to do that with some of the younger lawyers, along with other lawyers that are my contemporaries or perhaps have been practicing longer, and just continue to do that for our clients and enjoy the practice of law and being a trial lawyer. And so I think that's the short of it, that we want to try good cases and be great team members with one another. That's certainly what we preach at Salvi, Schostok Pritchard.
Pat, when you did your induction speech in the inner circle, your dad was there, and it was a touching moment. You spoke about your dad, and he, I think, came up on stage later. And I'm interested to know a little bit more about him, and what did you learn from him? What lessons or what aspects of his teaching did you have to put behind to find your own kind of unique, authentic voice for yourself?
Yeah, and I mentioned standing on shoulders, and I think this is a great example. And he and I talk about this because it's kind of a beautiful thing that, in a lot of ways, our identities are wrapped up not just as husbands and fathers, but as trial lawyers. Really, for my dad, so the comparison between the two of us would kind of go like this. My dad So my grandpa was a lawyer, and he was like the everyman's lawyer. He was in one of the suburbs of Chicago, and he wanted to do probate and real estate and criminal defense, and he would mix in a personal injury case. And so when my dad graduated from law school and joined him back in the late 70s, he would do all of the things that the firm was doing. Very small firm, him and my grandpa, and that might have been it at the time. And after a few years, he realized that he really enjoyed trial work. He wanted to be a trial lawyer, and he wanted to do personal injury. Particularly, he wanted to do medical malpractice. And he was in Lake County. So Chicago sits in Cook County. Lake County is the county immediately north of it. And nobody really, it's a little bit, it's more conservative, harder to get verdicts. So he wanted to be like the medical malpractice lawyer in Lake County, and he really set out to do that. And in order to do that, he left my grandfather's firm and started his own literally as I was being born. I joke with him, like, what a time to take a huge risk in your life. You got, your first child on the way. And so he then started his own firm and grew it over the course of the next 30 years before, I came into practice, or I guess 25 years before I came into practice. And over that course of time, he certainly established himself as a great trial lawyer. But at the same time, you can understand with that sort of coming of age story, there's an element of that is risk averse, where you have your own firm, you have your family, you are growing your firm and really starting from scratch. Whereas I became a lawyer in 2007, so I've been practicing for 18 years. And I come in 2007, and over the course of the next 7 to 10 years, as I find, kind of get my sea legs, I bring an element of more risk tolerance, and I bring an element of kind of enhancing the vision. But I'm not able to do that if I don't have this safety net, this kind of network that's already built in. So kind of the symbiosis of that, the way that our law firm has grown, and the way that I like to think that I've added value, but on top of what he already built, because this is my story. I don't know what would have happened if my dad wasn't a trial lawyer. He was. This is what I chose to do. And so one thing I love about our relationship is that we can reflect on what I think is a great kind of interplay between how he got this going, not that he doesn't continue to contribute to it, but how I've also brought my own element that he's enjoyed and appreciated. And really credit to him for putting such faith and trust in me and allowing me to be a key decision maker, not really second guessing all the time, but really giving me that autonomy, which has been wonderful as well. And that kind of sums up our relationship. I mean, there's a lot more to it, but that might be the best part.
I got a question here because this is, it's a pressure cooker sometimes trying a lot of these cases, and especially the righteous cases that you're trying with significant losses, Pat. What's the most you've rejected and then went and tried?
The most money, I would say.
Yeah.
So we had this case. It was the worst injury in terms of a client that I've ever represented. Not to compare clients, but just in terms of her pain and disability. So a woman was at O'Hare, and one of the bus shelters, if you've been to O'Hare and you're going to get your Uber or your taxi at the time or whatever, you go down to that lower level and there are these bus shelters. And it was a windy day, and lo and behold, for decades, the city had not been maintaining these bus shelters. And so it turned over and it landed on this woman. She was in her mid 20s, and it severed her spinal cord. And a severance of the spinal cord, as both of you probably know, is particularly awful, because on top of the paralysis, that shearing force to the cord can leave the individual with a horrendous pain condition. And so she had these two things happening concomitantly, and it was just really the worst injury that I've ever seen. We were talking about, this is back in about 2016, 2017, and we were sitting around talking about the case. And my dad was the lead trial lawyer on this one. And they were saying, well, we're thinking about asking for $100 million. And I said, well, why not 200 million? And so we went out and focus grouped that, and it really didn't provide much in the way of shock value. And so we ultimately settled on, I think in closing argument, my dad asked for 175 million, and during that case, they had offered us, I believe, 35 million, and the verdict was 148 million. So I think that was the most that we've ever turned down. And the judge was good about it. You know, she didn't put pressure on us. She didn't start ruling against us. She was like, "All right, you know, that's your choice." And then we got a fair trial. It was great. My dad and I both, we picked the jury. We had other lawyers trying the case as well. And that was certainly one of the cases that I think was a turning point for our firm, because at the time, and I think it still is, an Illinois record for a compensatory verdict.
Amazing. This is, I think, incredibly valuable for every trial lawyer to hear from you on this. How do you keep that offer that you know was there out of your mind so that you can go and try the case to the best of your ability instead of letting that kind of loom over your head?
Yeah. I think you have to have a confidence, right? And I think that if you have that confidence, you're able to do exactly what you just said. But where does that confidence come from? I think it comes from two places. There's one thing I didn't mention when talking about my relationship with my dad and what he's taught me. Number one, I would say, is experience. So you could have kind of blind confidence, I suppose, but there's nothing like, particularly if you're going to go all the way to the end and take a verdict, right? Because as we know, you can settle at any time. You can enter into high-low agreements, which, you know, frequently are very important, and we do those all the time. We did not have one in this case. That we were trying to negotiate one, and we were unable to strike one just because we couldn't agree with the defense. And so, number one, experience. So if you've done it before, and you've got that experience, and you're able to say, hey, we can do this, I think that's very important. But perhaps more importantly, number two is your preparation. And I think that what I saw with my dad, and here's my favorite example, what he does with every deposition in a case he's going to try is he reads it once and he abstracts it. And it's a careful abstract. And then he goes, after it's abstracted, he goes through it again. And I do the exact same process. He goes through it again and he takes all of the questions from the beginning to the end of the deposition and organizes it by topic. And then you have, you know, whether it's 15 or 20 or 30 or whatever, however many categories, you've got them in a binder. And not only do you have it physically organized, you have it mentally organized, because you've gone through it so much and it's time consuming, but you're so ultimately prepared that when you get into the courtroom, particularly when you've done it a few times and you can see how that preparation really manifests itself in a courtroom, and you can see in the courtroom how you're way more prepared than your opponent, and they walk into mistakes during direct examination that you make them pay for in cross-examination, or vice versa. Like if they do something on cross and then you know what the facts are, and you know the deposition testimony so well that you come in on redirect and you blow their cross-examination out of the water because you went to the depths of preparation and they did not. And we did that in that case, of course. And so we knew that we were ultimately prepared. We had done all, focus groups, and we had our plan, and we knew that 35 million just wasn't enough. It didn't represent fair compensation. Would it have been enough for our client in her life? Maybe, probably. She was very young, but certainly in terms of fair compensation and what she was going through and ensuring that she always had whatever resources, not just to live, but to have a quality of life, we knew we wanted to go for more. And I think that helped not only our plaintiff, but other plaintiffs. I think it's those two things, the experience and the preparation, and then you can have the confidence to turn down that kind of money. But you also, as you guys know, you got to be nimble, right? And so if something changes and you need to adjust your strategy, maybe you do a high-low agreement, maybe you settle the case, and those are different avenues it could take. In that particular case, as I mentioned, the high-low discussion didn't bear fruit. We just were off by a little bit and ultimately took a verdict.
That's an incredible story. It doesn't suggest that your father's all that risk averse, despite your prior
Maybe
comment.
I had a little hand in urging him. Yeah.
Yeah, no, I mean, this is kind of the question I think so many trial lawyers grapple with is what is enough in terms of an offer, and is it enough that's going to meet your client's needs, for the rest of her life, or is it worth putting that at risk for more? And at what point is that, a rational or smart decision? And what point is our own ego as trial lawyers getting in the way of that? Or are we Are we at risk of giving bad advice because we have other motives in mind there? How do you grapple with that? I mean, at some point, there gets to be enough money that it can take care of somebody's needs for the rest of their life, and you are putting that at risk, right? On the other hand, like you pointed out, probably the life care plan and the needs of a young person. And when you subtract out all the things that come out, it actually isn't as much as it seems. And it really isn't a fair number given what the actual value of the case is. So how do you weigh those competing things? That's something we have to do in every case.
Yeah, no question. Well, certainly, careful discussion with your client is paramount. I mean, that's number one, right? We had an experience recently where there was, the trial had gone very well. There was significant discussion while the jury was deliberating about whether we should make any effort to settle or just take a verdict. Because the client could have ended up with nothing or very, very much next to nothing if we did not get a verdict against the right defendant. We've been in those situations. We knew we were going to win, so to speak, but if we didn't get the right defendant, it wasn't going to be anywhere close to collectible. And so there was that risk. We ended up with a verdict that was, and for other reasons, the verdict was read, but we had already obtained a settlement because it was multi-party. We still needed to hear the verdict, and the verdict was greater than what the settlement was. And so how do you think my client felt about that? Well, of course, there was a little bit of, did I make the wrong decision? I could have had more money. And my response to him was, hey, I've been on the other side of that, number one. So let's not forget that when we made the decision we were on, we didn't know what the result was going to be. That's number one. And then number two, the other benefits of a resolution, the finality of it, and, the uncertainty of an appeal and things of that nature. And ultimately, my client was, very much at peace with his decision, and the result was very big. It wasn't as though he resolved it for a small amount. Now, that same case probably could have settled for a third or less what it settled for had they come to the table earlier on. The competing factors, I think, Ben, that always weigh on my mind, and whenever you represent a client, you're representing that client. But at the same time, as lawyers, and this is maybe the crux of where we are put at conflict. If we only, for every client, if we only said, what's the minimum you need? And once we get there, we'll take it and we'll move on to the next case. I believe that our opponents, I believe that politically, I believe that the insurance companies and industry and corporations, they would chip away at us until there was nothing left. That would ultimately result in a swing in the civil jury system writ large that would hurt all clients. And so I don't think there's anything wrong with having a discussion with a client and saying, hey, look, this will take care of you. But in terms of resources where perhaps instead of just being able to pay for your medical and nursing care that you're going to need on a daily basis or whatever the case may be, given the nature of the disability, what if you have significant resources to where you can do more fun things? I mean, you're disabled, so it's more expensive, whether it's to fly or to have additional help or whatever the case may be. And you have resources where you don't have to worry about money. And so that's the balance that those, and of course, liability strengths have to play into that. But big picture, how important is it that trial lawyers like us are with the client's full-blown good faith consent, not us talking them into it for our own egos, but true consent and understanding and being on board. If you have clients like that, because sometimes your client isn't like that and you got to settle the case, and we've all been there. When you have that, I don't think there's anything wrong with us, for lack of a better phrase, going for it, because true accountability for what some of our clients go through. I mean, I'm talking about the gruesome, the horrific, the long-term, just the horrible things that we see on a daily basis. The true accountability for corporate misconduct, for insurance companies that are lowballing us. I don't lose a wink of sleep when those folks get tagged with some of the big verdicts that we see. And so when corporate America talks about nuclear verdicts or the McDonald's case and tries to slander us, I think any individual, that's part of the PR machine, but any individual, when you sit down and you talk to them about this concept, I think will understand that kind of accountability is extraordinarily important. And it's something that makes our country what it is and keeps people safe. And so with all of that, I think it's a fair thing for us to think about, so long as we are always being truthful and honest and transparent with our clients.
I mean, on that comment you made, Pat, about, big verdicts and nuclear verdicts, I haven't had a single one of my clients say, hey, I'm glad you got that verdict, because that's, I'd rather have the verdict than my life before this tragedy.
Yeah, right.
There's no amount of money worth what any of our clients have gone through, and they don't look at it that way. And I can't imagine any of these institutions, corporations, the people that cause these harm would want to be in the same position as any of our clients.
Yeah, no doubt.
You've obviously mastered is a strong word because we're all learning and trying to get better, but you are extremely competent and successful in the courtroom. And I've seen you present on a couple of different cases. For our listeners who are grappling with this, trying to get better as trial lawyers, give them some of the takeaways you've had from your career, and what are the, say, top 3 to 5 things that you've learned that made you a better lawyer and what you implement when you're in the courtroom. And we know, obviously, one of them is great preparation, which you've already alluded to, but talking in terms of sort of courtroom strategy and presentational aspects of what you do.
Well, I think it starts, as we all know, with not just literally, but with jury selection. You're making your first impression. Speaking of impressions, something I always try to tell the lawyers at our office, or if somebody asks me this question, credibility and impressions. To me, these trials are primarily about credibility and impressions. What credibility do you have, and what impression have you left with the jury after a 2 or 3 week trial? Now, I may come back to this, but in terms of the world of psychology, memory is so important. So in ensuring that what you're doing is memorable, we go first, 2-3 weeks later or more, the jury's deliberating, so making things memorable, but credibility and impressions. And so how do you maintain your credibility throughout? Number one, I try not to take any position, zero, not any position. Now, sometimes you have a good faith battle over a very difficult fact fight in a trial, but in terms of credibility, I don't want to take any position that is going to detract from my credibility. And that might involve even acknowledging contributory negligence at times, if obviously you have to be in a comparative negligence state, but maintaining your credibility. And then when I talk about impressions, with every witness, what impression have you left? It may not boil down to what was the answer. And I mean, the answers are, of course, important. But when the witness gets off the stand, how does the jury feel about that witness? And that's so important. But getting back to jury selection, I try to be the most energetic, likable person in the courtroom. When I stand up, whether it's, direct, cross, close, whatever it is, when I stand up, I want the jury to kind of perk up in their chair. And in order to do that, you have to bring energy and charisma, a likability, and be very prepared, because then the substance is what ultimately will carry the day. In terms of my examination, and for jury selection, I mean doing everything you can, understanding different judges and jurisdictions have different guardrails, doing everything you can to appropriately start theming your case, to start framing the issues in a way that is favorable for your case. Then as you get into the examinations, particularly adverse examinations and cross-examinations, I do a lot of malpractice cases like you've been. And to me, by far, the most important examination in any malpractice case is either the adverse, if you're going to call the person in your case, or the cross, if you're going to wait till the defense case, of the defendant doctor, the defendant nurse. Is the most important. And so I spend by far the most time on that examination, way more than any others, because it's like the 80-20 rule. That is the most important thing. And in my philosophy for those examinations, including crosses of experts or, other hostile witnesses, is kill shots. No oxygen, kill shots. If it's kind of flimsy, just leave it out. Examinations, they're not meant to be replete, right? They're not meant to be the whole case. So what are you going to do with this witness Kill shots, kill shots, kill shots. Whatever you ask, you have something to follow up with if they don't give you the answer you want. You have an algorithm. Are they going to say yes, no, I don't know, something else? You think through every answer they might give, and you know exactly what you're going to do. If you don't have an out, maybe you don't even go there. And so you want to deprive the witness of any oxygen and just have kill shots, so that at the end of that witness, the impression, getting back to credibility and impressions, is such that the jury's like, well, I can't believe that witness. The lawyer has credibility, the witness does not, and I'm not going to put any weight on what that witness testified to, because clearly they're not telling the truth. I would say those are probably the biggest ones. Maybe another one is, if we transition into closing argument, I'll tell you, I had already been doing a lot of what I think we all do, which is reading other lawyers' closing arguments, watching other lawyers' closing arguments, talking to other lawyers, and trying to gather as much as we can so that we can then use it in our case, apply it appropriately in our case, not rote kind of repeating, but applying it to our case, and then having the benefit of the wisdom of folks that are in the inner circle, the two of you and so many of the other amazing lawyers. Just having those resources, I would encourage any lawyer to enhance your network so that you have people to learn from, because you can use 3 or 4 or 5 things, for example, in a closing argument that maybe you never thought of, that are just incredibly powerful. And it's up to us to kind of, either with our own creativity, come up with it, or, a lot of what all of us do. And that is, thankfully, closing arguments are not copyrighted, because I think we all steal quite a bit from one another, but in a good way. You got to do it in the right way. But that's another thing, to just think so carefully through your closing argument. I mean, opening statement too. You asked for 3 to 5, Ben, and I'm not sure what number I'm on, but we could go on and on. But really applying every tool you have at your disposal to give an outstanding closing argument and motivate the jury to give a big verdict.
I'm feeling inspired. Unfortunately, now I have to jump to do the depot, but you guys continue the conversation. I'll listen to how it went later. But Pat, thanks so much for doing this.
Yeah,
it's really
man. Sorry
fantastic.
I had to start late and we didn't get more time with you, but
it's cool. It's
appreciate
cool.
it. Good luck at your dep.
Yeah, good luck.
Thanks, guys.
See you, Ben.
Take your playbook to the next level by joining a legal network of all-stars at psrplaybook.com. psrplaybook.com is a free digital legal library created exclusively for plaintiff lawyers by the nationally recognized personal injury law firm of Panish Shea Ravipudi LLP, and features video content showcasing the tactics, strategies, and concepts implemented by some of the industry's most successful trial attorneys. psrplaybook.com promotes learning, shared knowledge, collaboration, and best practices. Get in the game and see for yourself by joining our national network of plaintiff lawyers. Subscribe now at psrplaybook.com and learn from the best.
So talking about your cross-examinations and kill shots and taking away the oxygen, is your approach to elicit only yes or no or I don't know answers, or do you sometimes take the liberty and allow for open-ended questions?
So I think, by and large, because I don't fully subscribe to what was his name? Irv Younger, the 10 Commandments. I should know the name. I don't fully subscribe to only ask yes or no, only close questions during cross. However, I would say that by and large, almost all of my questions are yes or no. But what I like about that is when the witness does start to run, if you've done your job, you've asked a good question, you've set it up right. Now the defendant or the defense expert is feeling cornered and they start to talk more. The last thing I'm going to do, because I think when defense lawyers do it, it's a grave mistake, and you see it a lot, is they jump down the witness's throat. That's it. You've answered the question. Thank you very much. And it just looks like you're afraid of what they're going to say. Whereas if you let them talk for a little bit, now there's some risk there, because if it's a very likable defendant, they might make a very favorable impression. So there's nuance to this. But a lot of times, if you set it up right, you ask the question, it's yes or no, they start to run. the jury can see that they're being defensive. The jury can see that they're being non-responsive, and it only hurts them. They give them the eye roll. And we, as the lawyer, don't want to take the attention off of the non-responsive answer by, Your Honor, move to strike. No, what I typically do is I'll be very calm. I might say, well, I think you may have answered a little bit of a different question. Why don't you, maybe you could answer my question. Or I might say, let me try it again, and I'll ask it again. And then if they run again, at that point, now the jury's like, man, can we put an end to this? And I might say something like, Your Honor, I think the witness is going a little bit beyond what I asked, something like that, as opposed to being harsh and angry, because I think that makes you look defensive. And I mentioned in a prior answer about, being likable. I mean, let's just face it. Psychology is such that people are going to listen to what you're saying, and they're going to believe what you're saying more if they like you. And so you want to be the best version of yourself. And I think that includes, with an adverse witness, not getting all fired up when they don't answer. At least that's not my style. It might work for some other folks. Doesn't really work for me. I learned that the hard way early in my career and changed my approach.
I want to kind of stick on the same thread here, but ask you a couple of questions here. I can't believe it, but I mean, it's so amazing. But okay, $363 million verdict on a toxic exposure case, $148 million on a paralysis case, $79 million on a police pursuit case, almost 80, 75 on a brain injury case, 33 million in Lake County. You've tried cases in Oregon on the fire cases and got massive verdicts there. Two questions. I want to ask about whether your process in preparing for these trials over the years has gotten easier. Like, have you developed some efficiencies and found where you need to focus your time? Or is it the same grueling process as it was the first time you tried a case? And second, I'm always curious about how your style and styles change in different venues, or if you've been able to develop a trial presentation strategy which is receptive to any audience, no matter how conservative or how liberal or however you want to characterize the jury demographics as being. Are you able to sort of develop these universal truths and universal messages that resonate with everybody?
Yeah. Well, I do think that my process for preparing for trial remains the same grueling. I would say more grueling, because as you learn what true preparation looks like, you realize just how many hours you have to put in. To me, there's no silver bullet, there's no shortcut. There are certainly things out there nowadays that are very helpful. I mean, AI being kind of the obvious example, but that can help with doing medical literature searches, which maybe a few years ago was a more laborious task than it might be today. But all that being said, I've said this a few times, so I don't mean to sound like a broken record, but when I'm talking to the associates at our firm, who I have just a deep desire to help them turn into outstanding trial lawyers, I try to impress upon them, I don't think I'm any better or smarter than anyone. I do think that I've gone out and gotten a lot of experience that maybe a lot of trial lawyers have not, for whatever reason. I attribute a lot of that to my own good fortune. And then also, beyond just experience, hours. And so the process is the process. If for a particular witness, it takes X amount of hours to put together an outstanding adverse examination or direct or cross-examination, then that's what it takes, and you have to sink in those hours. So I think my process has probably become more grueling, although what I will say is I love big teams. And the reason I love big teams goes back to what I said before about how important the cross-examination or adverse examination of a defendant doctor is, and that is I can focus on that if I have another lawyer and then a third lawyer and sometimes even a fourth lawyer focusing on other examinations that are very important, need to be done with excellence, but something that they can handle based on their experience level, that they're going to do well, that I can give them counsel on, and I don't have to spend a minute on that beyond counseling them, and I can focus entirely on what's most important to win the case. the existential witnesses. So that is very much true. I bring big teams to my trials. In terms of my presentation to juries, I've been, and you mentioned the Oregon cases, and candidly, we would have liked a bigger verdict in that case. And those were interesting cases. And that was the first time I'd ever tried a case outside of Illinois, but I have been all around Illinois. So I've tried a lot of cases in Cook County, but I've tried cases in Lake and McHenry and Winnebago and Pope. I've got one coming up in Madison County in February. And so I've been kind of all around the state. And I think that the way I would put it is I'm still me. I'm not an actor. I get a motion in limine every case that says Mr. Salvi's going to cry, and the judge needs to admonish Mr. Salvi not to cry. I say, Judge, if this was acting, I wouldn't be a trial lawyer. I'd be an actor. I'm not that good. Believe me, it's genuine and some combination of raw emotion from my client and just being dead tired after, a 3-week trial. But my presentation, I think, has remained the same wherever I am. But I do think you need to understand your jurisdiction in terms of how to talk to whoever you're talking to. So a Cook County jury, I may not so much in my persona, my presentation, who I am, because I don't want to change that. I want to be authentic. I think authenticity and being genuine it goes along with that credibility piece that I don't think you can set aside in any way, shape, or form. But at the same time, how are you going to address jury selection knowing you have more conservative jurors in one jurisdiction versus more liberal jurors in, for example, Cook County when you're in Chicago? So I think just in terms of how you frame your arguments, that might be different. But for me, I would say what I do, how I do it, that remains the same while making adjustments for who your audience is.
No, that makes sense. That makes sense. Talked about all the hours you put in. Now, you've got a beautiful family and wife. How do you balance, and for all the trial lawyers out there listening, seeing the success that you've had, where's the sacrifices? How do you maintain it? How do you keep this energy and carry it into the home as well?
Yeah. Well, and Rahul, the same applies to you. I had the good fortune of meeting your family and your kids and your wife, and I know you deal with the same thing. And so for me right now, I've got my main responsibilities are as a managing partner of the law firm, and then as a mentor, and then really as a trial lawyer. And so I have kind of structured my practice where I still participate in discovery to a certain extent on certain cases, typically later on in the case, but for some cases at the beginning. But I'm not handling like 30, 40, 50 files from beginning to end. That's not really how I do it. And so really what I have are a handful of cases that are set for trial in the relatively near future. Some of them settle and some of them don't. The cases that I'm working on have a higher percentage of trials than the 2% that you kind of hear about, colloquially about how few cases go to trial in the civil court system. But that's by design. And so really I spend most of my time preparing for some trial. And when you're doing it like that, and I probably have depositions here and there, but it's not nearly as frequent as it used to be, just because I've adjusted my practice. And so that gives me a ton of flexibility. So I can be abstracting depositions in the morning, take my kids to school, go into the office. Sometimes I might stay late. Sometimes I'm coming home for the baseball game at 3:00, or I'm leaving the office at 3:00 during the summer to make sure my son gets to his baseball game on time. So it's a daily kind of push-pull. And then, as you know, at times you just have to say, my wife's name's Juliana. I have to say, sweetie, Juliana, for the next couple of weeks, I'm just going to be out of pocket. It's prep time and then the trial, and I just have to be out of pocket. That probably is 2 to 4 times a year when it really goes the distance. So I think with that, I think it's doable. I think I personally, just because it's like kind of a hobby, I enjoy it, and I think cognitively, physically, it's a boost, is to make sure I get some exercise pretty much every morning. But truthfully, And here's the sacrifice, I would say. I'm not looking for anybody to feel sorry for me. I don't have a ton of friends. I exercise. I play a little guitar. I've got a couple of things, but other than that, my hobbies are just to be with I got a 10, 8, and 3-year-old, and that's how my time is spent. And I try to see friends when I can, and neighbors and people that are at my kids' school and all of that. I try to do that. I'm a big sports fan, so that's another hobby. But by and large, if you were to dissect my time, it would be the practice of law and my family. And so those are certainly my two focuses. And I think if those are your focuses, then there are enough hours in the day to satisfy them.
It's amazing. Oh, I wanted to ask you about this. You talked about teams. I'm like you. I love having a lot of people at trial with me. I love giving attorneys an opportunity, young and new attorneys an opportunity to put on witnesses. And I imagine that there's been discussions within the firm or even outside the firm with colleagues about whether there's dilution in your connection with the jury if you allow other people to put on witnesses or play a role in your trials. So how did you evolve from wherever you started to where you are now? And for those who think it's only should be one person with the spotlight on them, what's your argument for why teams are better?
My first argument for why teams are better, and this is another saying that I try to push, is everything needs to be done with excellence. And if something's not getting done with excellence because there's a shortage of time, let's bring someone else on so that it can be done with excellence. And what's the counter to that? I'm not sure what it would be. Some tasks don't demand excellence. I disagree with that. And so my last trial, we had 4 lawyers who had at least one witness. We had one lawyer who's been a practicing lawyer for 5 years, but just with us for, I think, approximately a year. And she had 2 witnesses. She did a wonderful job. They were lay witnesses regarding damages. And so I'm sure at her next trial or within the next couple trials, she'll be able to level up. So that's important. So that's someone who's been there, done that, and can take on a greater responsibility. And then I had 2 other lawyers who, one of which actually was just named partner, and the other has been a partner for a little bit now. And, they had experts and they had important eyewitnesses. And so they took a load off. And then for me, that allowed me to focus on both of the defendants, the 2 supervisors of the defendant driver, the truck driver. It allowed me to focus on presenting our crash reconstructionist, presenting the key treating orthopedic surgeon, cross-examining the defendant reconstructionist, because not only do you want to set up these teams so that there's a spread in terms of responsibility, but on the daily, you want to look at each day and say, okay, if we look ahead on Friday, so-and-so has 4 witnesses coming, maybe one of those I can take off your plate so that you never like to do that mid-trial because you'd like to have that worked out in advance, but you know what I mean, in the sense that, you don't want someone at the end of a day with their 3rd or 4th witness, just, you can't even remember, you can't keep it all straight in your mind. So I think the benefits of having those big teams vastly outweigh any concern for dilution relative to connection with the jury. And quite frankly, in my experience, having gone through enough trials with 3 or 4 or even 5 lawyers handling witnesses, my experience is that, okay, the lead lawyer is typically handling maybe not every big witness, but most of them. And that lawyer I would imagine, has picked a jury. So I mean, picking a jury is like my favorite thing. I love picking a jury. Some lawyers say they don't like it. I don't know why. I think it's the most fun, exciting, thing.
I'm with you.
Yeah, right. And that's where you kind of start that connection. I don't think you necessarily lose that so long as you're doing your job. And then when you get to closing argument, I've never felt like in those cases where you're rolling and you've won every day and you're giving your closing argument and you're saying it and you believe in it and you have credibility and you're on the right side of the case and you got the evidence and you've won the evidence and you're giving that very authentic, genuine closing argument. I've never felt even for a moment that connection was diluted because I didn't take on more witnesses. And in fact, if I took on more witnesses, would I have done a less than stellar job with some of those witnesses that maybe would have dinged my credibility? I don't know. That's kind of a hypothetical that we don't necessarily know the answer. But when I hear lawyers are trying cases by themselves, like there are some cases where that's probably fine. But complex cases, I mean, that would concern me. And maybe there are lawyers that can do it. That's not for me. And I think to the extent there's any dilution, it's vastly outweighed by the excellence you get by giving people the amount of time they need in order to do any examination in an outstanding way.
Totally agree with you. Oh, Pat, I could talk to you forever.
Likewise. Yeah.
Yeah, no, thanks so much for joining us. Hey, if anybody wants to reach you, talk to you about a case and maybe bring you on or just get some advice from you, what's the best way for them to reach you?
My email is psalvi2 at salvilaw.com. So P like Patrick, Salvi, SALV as in Victor, I, the number 2 at salvilaw.com. I give my cell phone out freely, so I don't mind. 847-903-3792. If you call me, I probably will not pick up because whenever I get a random phone call, I assume it's some congressman asking for money. But if you text me, I will respond.
Or you get that your loan has been approved for $35,000. So
Yeah,
just give me all your information now.
That's right. That's right.
Well, Pat, thank you so much for joining us. I cannot tell you how impressed I am by everything you do, all the good you do for the community, and how you deal with a smile on your face and help your clients in the most amazing way. So thank you for being you. Thank you for being a friend. Thank you for joining us. And hopefully you'll come back on soon.
I would love that. Rahul and Ben, thank you so much for having me on. I'm a listener, and so I was very excited to get the invitation and thankful. Hopefully, there's a nugget in here, one or two, for any of your listeners, because you've had so many amazing guests that to be part of that list is an honor. So thank you.
Thank you.